Hi everyone, my name is Kamlesh Ranavardi. I am a co-president of ColumbiaDC and a graduate of the School of Engineering and Applied Science. I would like to thank our partners at Cal Club of Washington, D.C. And their members for joining us in this gathering. We are very honored to have General Counsel to the House of Representatives, Douglas Letter, to discuss Article 1 of the Constitution, in particular, the congressional oversight of the executive branch. We are also fortunate to have CNN legal analyst Elliot Williams as our host. So please allow me to briefly introduce our speakers, but I would encourage everyone to check our website for their full bio and detailed list of their storied accomplishments. Douglas Letter has been the General Counsel to the House since January 19. This is after a 40-year career at the U.S. Department of Justice, during which he served among various roles as Associate Counsel to President Clinton, as Deputy Associate Attorney General under AG Janet Reno, and as Senior Counselor to AG Eric Holder. Letter received his law degree from the University of California, Berkeley Law School in '78, and his BA in American History from Columbia University in 1975. Our host, Elliot Williams, is a CNN legal analyst, also a principal in the Raben Group in Washington, D.C. He has spent 8 years as a senior political appointee in the Obama administration as Deputy Assistant Attorney General for Legislative Affairs at the Department of Justice. He earned a law degree as well as a master's degree in journalism from Columbia University and a bachelor's degree from the University of Pennsylvania. Elliot, passing this on to you.
All right. Can you hear me?
I can hear you fine, Elliot.
Oh,
can you
good.
hear me? Good.
And I see Douglas and Letter. Good to see your face again. How you doing?
Excellent. How about yourself?
I'm wonderful. And I don't see the unnamed collection of Columbia and University of California, Berkeley folks, but I'm sure you're there, and welcome and thank you for joining us. So let's talk about a few things. First off, when we were prepping for this, Doug, you know, one of the things we talked about was your history going back to the exciting times when you were both in college and law school, right? Just in terms of political involvement, engagement, and so on. I've got one to talk about too, but tell me, you have the floor on that. Like, so this is the personal part of this before we get into the Article 1 discussion, right?
Well, when I was at Columbia, which was 1971 to 75, things were very interesting for at least some of us who were male and of an age to be drafted and sent to Vietnam. So there was all sorts of anti-Vietnam War activity going on at Columbia. It was nothing compared to what things were like in 1968 there, but there was quite a bit. I remember specifically one large demonstration because the U.S. forces had gone into Cambodia, and that seemed like it was even escalating the war even more. And so there was a lot of activity on campus about that. So that was definitely very exciting and interesting times.
And the interesting thing, so when I was at Columbia, I was there for Bush versus, I'm a couple of years younger than you.
Yeah, just a few.
No, I was there for Bush versus Gore. And I remember the whole episode, so from Election Day through the recount and so on. And I remember I said to someone, this is the kind of things we talked about at Columbia Law School, wow, we're in a constitutional crisis, right? We know it's not a constitutional crisis. This is exactly how the systems of government are functioning. Now, this is high profile and it's tense, but it's not a crisis. And we can talk about that today too. What constitutes a crisis? What comes to be the point at which our systems have broken down and don't work, you know? But first, big picture, before getting into any of this, what is Article 1 of the Constitution? I think we are going to have a discussion like as two smart people talking to an audience of smart people, but they're not all constitutional lawyers. So big picture, what does Article 1 do of the Constitution?
Okay. So first of all, here it is, the
There you go.
pocket Constitution. Never be without this, Elliot, right? One of my daughters carries one in her purse. Very impressive. So for those who don't know, you know, the Constitution has three main articles that set up our government of separated powers. Article 1 is where it sets up the legislative branch. So, and Article 1 right up front sets up the House of Representatives, the People's House, and then there, you know, the Senate, and it talks about the qualifications for the House and the Senate, and it says that some key provisions. All legislative power is with the Congress. And one of the big things has come up in a batch of cases recently is that each House of Congress sets its own rules. And then Article 1 also talks about some of the powers of Congress and some of the restrictions. Article 2 then talks about the president, the presidency, the command, that he's the commander in chief, et cetera. And Article 3, which is much shorter, sets up the courts. And it only mentions the Supreme Court and then such inferior courts as Congress would create.
So great. So let me, if I am capable of sharing my screen, which you know, bear with us here.
You're very brave, Elliot.
I know, right? Here, let's see if we can do this. Hold on one second.
Oh, yeah.
Okay. Oh, so you got the picture?
There it is.
Okay.
Yes, beautiful.
Beautiful. Okay, so here's the deal. And I wanted a picture of, this is, as you might know, this is President Trump giving us State of the Union. I don't know what year it is, but obviously he's President of the United States. Okay. I don't, and some folks who are here may disagree with me, I don't want to make this all about Donald Trump and Donald Trump against Democrats or whatever, right? The temptation is always to do so. However, I don't know if this is about Donald Trump as much as it's about the president versus the executive. And even one of the questions that I've already seen come up, and folks who are watching can pose questions and keep them running through it, and then we'll get to them, you know, is specifically about Donald Trump. But let me just read to you a couple things from the President of the United States. So November 12th, 2018, this is right after the Democrats would have taken majority of the House of Representatives, right? The president tweets, it's just after the election. The prospect of presidential harassment by the Dems is causing the stock market big headaches, okay? December 6, 2018, 3 months later, or a month later, he tweets again, without the phony Russia witch hunt and with all that we've accomplished in the last 2 years, tax and regulation cuts, judges, my approval rating would be at 75% rather than 50%, just reported by Rasmussen. It's called presidential harassment. He used those words again. February 7th, 2019. Now Congressman Adam Schiff announces, after having found zero Russian collusion, he's going to be looking at every aspect of my life, both financial and personal, even though there's no reason to be doing so. Never happened before. Unlimited, say it with me, presidential harassment. April 4th, 2019. There is nothing we can ever give to the Democrats that will make them happy. That is the highest level of, say it with me, presidential harassment in the history of my country, right? Then the president tweets, presidential harassment. This is March 5th, 2019. He tweets it again and again and again and again and again and again and again, just the words, sometimes all caps. Here, this newest one is in lowercase, again and again and again and again. By my count, the president has tweeted the words presidential harassment 39 times over the course of the presidency. Now, I don't say this to mock the president of the United States or criticize the president of the United States, but he has framed the relationship with Congress and him as one of harassment, and one in which any incursion by the House of Representatives or Congress generally is harassment of the president of the United States. It's sort of this binary, either they're harassing me or they aren't. So my question here is, let's just start from this premise, right? What is congressional oversight? And what does it mean for the House of Representatives to actually engage in oversight of the president?
So, Elliot, that's a splendid question. I really like the way you set that up. That was terrific. And I think this is one of the unfortunate misunderstandings by the current president of how our government works. That he calls all of this presidential harassment. And by the way, he said he's not going to be responding to any of his administration will not be responding to any of the subpoenas that the House issues. I believe that he thinks that oversight is harassment. But let me put it this way. If you have a situation where, let's say you set up an entity and you're funding it out of your own pocket, the entity isn't allowed to have anything to do with funding. And the entity comes up for renewal regularly. And you say, okay, I want to know, what are you doing with the funds that I'm giving you? And how are you, and I gave you some directions also. I said, and set some goals for you. I said, you can do this, you can't do that. So tell me, how are you doing? And do you need more money? Should I give you more money for this, but you don't need as much money for that, et cetera? Think about how you would react if that entity, the head of that entity, says, don't ask me any questions, go away, you're harassing me. You'd say, whoa, wait a minute. I'm the one who provides the money. I'm the only one. Nobody else can give you money. And I'm asking you, how are you spending the money that I give you? I'm the only one who can give you directions. Now, we set aside the president of the Constitution has certain powers that are only from the Constitution, but his power of executing the laws comes entirely from, under the Constitution, from Congress. Congress sets us laws. So Congress says, tell me how you're doing it. What are you doing? Should we change this law? Should we change that law, et cetera? And that entity is saying, go away, just keep giving me money. In fact, give me more money and stop telling me what to do. I don't want to hear it. And stop criticizing me, stop asking me questions, just go away and give me more money. You would say, there's something wrong with this system. And I think that's the problem here with the president. I don't think he's not used to operating in this kind of system. Obviously, as we know, he knows very, very little about how the U.S. history or how the U.S. government works. And so he's mistaken. He doesn't understand what totally legitimate oversight is.
And, do you tell me about your views on the theory, as has been put out by some scholars, including Congressman Jamie Raskin, who's a member of the House of Representatives now, that we hear the term co-equal branch of government, that there are 3 different co-equal branches of government. He, for a long time, as a constitutional scholar, said that's actually not true, and Congress is itself first among equals, right? Yeah. And it's partly that funding question that you put out there, right? And that it comes first in Article 1, and that everything else goes to Congress. Congress allows the Justice Department to exist, right? So, do you buy that argument, or are we really just co-equal branches that check each other? Sometimes one's on top, sometimes one isn't.
Well, certainly, first of all, Jamie is my representative in Congress, and he's my friend. So, of course, I'm going to agree with him. No. Jamie also happens to be extremely smart and extremely articulate and extremely energetic. I think Jamie has a very good and basic point there. And I've said this in court on more than one occasion. I've said President Trump seems to have forgotten that we are the first branch. And really remember, the president is obviously elected by the people, but the House of Representatives is of the political bodies. The House of Representatives is by far the closest to the people. They're elected every 2 years, and by a smallish group. One way of answering your question is, well, there are 3 branches. I don't think anybody thinks that the judiciary is the equal of the executive or the legislative branches. Judiciary obviously has an absolutely essential function, but as we know, the judiciary can't do anything on its own. It only rules on cases or controversies brought before it. It only has jurisdiction as Congress gives it. And Congress can do away with all the federal courts except the Supreme Court if it wishes. Elliot, I know you know this. Early in our history, there were very few federal courts. The Supreme Court had almost nothing to do. Almost all law was done in the state courts. And overwhelmingly still, most cases, as I say, overwhelmingly are in state court. So I don't think it makes sense to say the judiciary is the equal of the executive and legislative branches. Look, the president has, as I said, he's the commander in chief. He has certain powers, some of them, subject to Senate. So, he recognizes ambassadors, he can enter in treaties, but they have to be ratified by the Senate. But it comes back to what you said a moment ago. The House and the Senate have the appropriations power, and you can't run the United States government without money.
Tell me this, and back to this question of sort of history. How unprecedented, so, I was light about the presidential harassment point and this question that, not complying with subpoenas or not, bending the knee to Congress or whatever. But how unprecedented is that conduct in relation to the arc of American history? Like, has it always been the case that there's a tension between the executive and the legislative branches, or is there something different going on today under this president right now?
The answer to both is yes. There has always been some tension, and I believe that this is unprecedented. And let me give you an example, Elliot. In the Civil War, Republican president, the first Republican president, and a Republican legislature. So very much from the same party, and overwhelming, because once the Confederate representatives are gone, the Republicans have a massive majority in the House and the Senate. As President Lincoln started prosecuting the Civil War, he really wasn't doing a very good job for quite a while in the beginning. The House of Representatives set up a committee to investigate the conduct of the war. Now, as we know, the president's the commander in chief. He says, 3rd Division, go over there. 1st Division, come here. Yes, but as we know, Congress appropriates the money. And so Congress held numerous investigations of how President Lincoln was doing and was extremely critical of him. So even when you have a situation of a president in a time of crisis with a Congress that is totally in line with him as far as party, et cetera, there was massive conflict between them. Then you get other situations, the Roosevelt presidency. I don't think he had much conflict. But then let's look again, Elliot, at just one more example, Lyndon Johnson. So Lyndon Johnson wants to get, and before him, Kennedy. Kennedy wanted to get through civil rights legislation, despite the fact that his party was in control. He couldn't do it, right? Lyndon Johnson made a whole batch of deals, sometimes deals with the devil, and he got it through, but it took an enormous amount of work.
So last, I think, Trump-facing question, but do you think, and again, this gets back to this question of harassment or not harassment, what right does Congress have to investigate under Article 1 and so on, or at least conduct oversight, not even investigate? Do you think we're in a moment now where there's just a shift in the relationship between the president and Congress, and now the president, future presidents, be it President Biden, be it another Trump, be it whoever succeeds President Trump, can just now start to say, well, I am not going to submit to your subpoena requests. I am not going to comply. Or is this an aberration where, for this 4 or 8 years, we just happen to have a president who has taken a more adversarial tone or relationship with respect to Congress's ability to oversee him and his administration?
Elliot, I think that it is very much an aberration. I hope we never see this again. Now, as I recall, I think both you and I were at the Justice Department when, for instance, Attorney General Holder was being investigated by the House for just about everything you can think of. But nevertheless, there was considerable cooperation. Now, I think part of the problem is when the Senate is the same party as the president and the House is not, which does happen.
Right.
As we know, the Senate, in one sense, has very particular power since they have the consent over appointments. So they hold all sorts of power over the president. They can basically say, we're not approving any of your, we're not going to consent to any of your appointees, judicial, cabinet level, lower level, military officers, nothing, unless you actually send your attorney general up here and have him testify in an oversight hearing. And the Senate can even say, we're not going to approve the attorney general's there, but he doesn't have a deputy attorney general. We're not going to approve one unless he actually goes and testifies in the House too. So the Senate can wield all sorts of power that the House alone cannot. And the House alone has the govern appropriations. They can make sure that there aren't any appropriations for things the president wants. But that obviously gets very delicate because there are so many things that both the president and Congress agree on. They agree that the military should be funded. They can have disagreements about how much or things like that. But is the House really going to say to the president, you did, the attorney general until just now, won't come and testify in a regular oversight hearing. So we're not going to fund the Defense Department. You can do that, but you can't do it a whole lot. And, we saw when both the House and the Senate said to the president, we're not funding a border wall. We had the longest shutdown in American history, a complete disaster for the American people and the American economy that the president brought on himself.
So at the risk of sounding defensive, I worked in legislative affairs of the Justice Department during the Obama administration.
Right.
And often, and frankly, by being on television, folks will often, on Twitter or whatever, come after me and say, well, you're criticizing the Trump administration, but Operation Fast and Furious and all of these other places where the difference, and I want everybody to understand this, and this is as much a political science point as it is a partisan one. The difference between Fast and Furious and any of the oversight that happened during the Obama or Clinton or Bush administrations, because I was there, I was on the Hill for the U.S. attorney firings in 2007. The difference is there was a process of negotiation where the president of the United States and the executive branch recognized that Congress had some right to investigate, or at least some right to conduct oversight. Now, they didn't agree over how many pages of documents needed to be turned over. And that was the fight in Operation Fast and Furious, or in the oversight over Fast and Furious. It was the DOJ had already turned tens of thousands of pages over, but Congress wanted more, and that went to court, and ultimately those documents went. The difference today, and this is a historical point, the difference today is that the president simply, and this is why we started with the presidential harassment, but why I started with that, simply has said that, well, I'm not going to submit to any subpoenas or sending any witnesses to testify. And what we saw yesterday, regardless of the partisanship of the hearing, was the first time the Attorney General had sat for the House Judiciary Committee in 18 months, which is kind of unprecedented. Right?
Yeah, Elliot, I couldn't agree more. As you probably remember, part of that time I was Eric Holder's senior counsel, and so same thing. I was, witnessing that. And just to drive the point home, because I'm concerned somebody may say, well, but the Trump administration is giving you documents, and the answer is, we have had certain situations where we said we want particular documents or we want somebody to testify, et cetera. And they say, we gave you thousands of pages of documents. That is true. They weren't the documents we wanted. We said that you gave us whatever, several thousand pages of documents. We didn't want them. That's not what we asked you for. So, it makes a nice public relations point, I guess, say, oh, the House is never satisfied. We gave them 10,000 pages of documents. Well, but fine, they may as well have given us, the New York City phone book. We didn't ask them for those documents. We want totally different ones.
So let's talk then about subpoenas and how they come. And the world of subpoenas sort of shifted a little bit, I think, in the last 2 weeks with the Supreme Court ruling and the Mazars case.
Mm-hmm.
So first, for the non-lawyers, let's talk about the concept of a 4-part test, right? Which is sort of this thing that lawyers talk and think about, but may not be intuitive to everybody. The way I describe the test is, in order to be allowed to do something, you have to sort of meet a couple factors, right? In order to be allowed to, right? How else would you describe the concept of the 4-part test?
Well, I think you're exactly right, Elliot. The Supreme Court, as we know, loves whatever it is, 4, 3, 27 point tests. They adore these things. I'm not 100% sure why, but anyway. So the Supreme Court, for the first time, set out this 4-part test. Now, there's something that I feel gets lost a lot of times in media reporting, and I'm sure, though, on CNN, you have not gotten lost in this. Remember that was an extremely narrow case. It was about getting personal records of the president, so not official records. We're not talking about, for example, under Nixon, getting the White House Oval Office tapes or something like that, or Fast and Furious, So there's the personal records of the president while he is president, from, in that case, a third party or from the president. So there are very, very few cases that are going to be governed by the Supreme Court's decision. And I've been told it's Mazars. I don't know.
Mazars, not Mazars.
That's what I was told. I'd never heard of the group before this all started.
Davos, Switzerland. I've learned to pronounce Davos.
Oh, okay.
Another
Who
one.
knew? Who knew?
Anyway, proceed,
yeah. And by the way, my name is Latour, not Letter.
I'm Elliot, so it's French, actually.
So it actually is going to govern a very small number of cases. What we showed in our briefs, we showed there was a long history of Congress actually obtaining personal records of the president. In fact, it goes back very far. And because presidents throughout history had cooperated to greater or lesser extent with giving documents to personal documents to Congress. So one of the things that constantly was pointed out is there are no lawsuits, where the House sued the president to get documents. Well, what we find out was that's because we didn't have to. President Grant gave over. In fact, the House obtained letters that President Grant had his wife send to her brother-in-law, who was involved in a scandalous fraud situation. And we show that throughout history, there were all sorts of personal records of the president. We got tax returns from Nixon. Everybody thinks, well, yeah, you got those through, he voluntarily turned a batch over at a certain point. But what people don't know is, but we wanted more. And in fact, he eventually gave us the tax returns for himself and his family.
Oh, wow.
And it led to, and I think people have forgotten this, it actually led to a situation where it turned out he owed a lot more money, and he ended up paying more money, having nothing to do with Watergate or anything like that. Jimmy Carter, Congress got all sorts of documents, family business documents about the peanut warehouse, et cetera. So, and as we know, in the Clinton administration, the Whitewater investigation, Congress got records that actually were found in the personal part of the White House. They were billing records of Mrs. Clinton in her law practice. So, any sort of notion that, well, you don't get personal records of the president. Yes, you do. We got them lots of times.
So let me walk, because I have it in front of me here, and I wouldn't put you on the spot to make you recite the 4-part test.
I've already forgotten.
because you don't plan on suing again. But or no comment on that. But but I want to walk through what the standard is now for the issuance of a congressional subpoena for personal records of the president, and then get you to talk about, is this workable? Does it make sense? So in order to get those records, or to subpoena those records, one, courts should assess whether the legislative purpose of Congress warrants the step of getting papers from the president, right? Yeah. So whether there's some need legislatively to get the president's papers. One. Two, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objectives, so like sort of a narrow subpoena. Third, courts should be attentive to the nature of the evidence offered by Congress to establish that a subpoena advances a valid legislative purpose. So that's the third time they've used this language of sort of valid legislative purpose, right? And fourth and finally, courts should be careful to assess the burdens imposed on the president by a subpoena. How much does being subpoenaed hurt or impede the president's ability to do his or her job? So you as the lawyer for the House, is that a good workable standard for the whatever you call it, the seeking of documents from a president?
Yeah. And obviously it ill behooves me to criticize the Supreme Court, because I'm going to be back. I already have 2 cases that will be argued in the fall, but I'm going to do it anyway. I'm going to just be completely reckless here and go crazy. No, I think it's a terrible test for certain things. One, we can't have the courts deciding whether these are legitimate legislative purposes or not. And this came up at the argument, the justices were saying, well, sort of, what's a legitimate legislative purpose? And I pointed out that since we provide all of the money to the federal government, there is almost nothing the federal government does that doesn't involve a valid legislative purpose. We want to know, should the Justice Department funding be cut back? Should there be more money for the FBI? Should the CIA, you could say, well, the military, the president's commander in chief, why, it's not a legitimate legislative purpose for Congress to look into that. Well, it is, because as I say, that the United States Congress could tomorrow decide we're just not paying for a Navy anymore. We could do that. And nobody could say, no, you can't. We can. We could say no money for any more aircraft carriers. Aircraft carriers we think are dumb. No more. So virtually any subject is a valid one for a valid legislative purpose. Now, you can say, as we know, Congress can't criminally prosecute anybody. I know you're a former prosecutor. You know this better than I do. But we concede that. So we couldn't, for instance, do an investigation saying we want to see whether to prosecute the president. Obviously, that would be illegitimate. But we pointed out to the Supreme Court, for example, that the subpoena to Deutsche Bank for records they had with regard to the president, that was part of a much larger investigation into the role that U.S. banks are playing involving Russian oligarchs and kleptocrats laundering money, getting billions of dollars out of Russia and cleaning it up. Well, that's
just one follow-up point, just for folks who aren't, because this is in the weeds a little bit. There was Mazars and there's Deutsche Bank. There's 2 different cases, right? Deutsche Bank was actually the president's financial record. One is a bank, one is an accountant. And you were, as I understand it, seeking documents for 2 different purposes, right? And
yes.
Right, and what you're getting at here was these were sought for a broader investigation into Russian intrusion.
Exactly. And we pointed out that the subpoena there, we subpoenaed a whole batch of banks, the overwhelming majority of which had nothing to do with Trump. We investigated a batch of Russian oligarchs, as I say, who were moving money. And so it was part of a much larger investigation. So it clearly, there was a valid legislative purpose, because remember, Trump was, before he was president, and maybe while he still is, he's a real estate mogul who has been heavily involved with both Deutsche Bank and Russian business. So I don't understand how that anybody could think that, well, that's not a valid legislative purpose. The subpoena to Mazars, for example, we said we needed to probe Trump before he was president, obtaining the lease from GSA for that fancy hotel in Washington, D.C. that, you and I have walked past any number of times. We couldn't get we tried to get the documents from GSA, but we had a sense that, and then we had people like Michael Cohen saying, and you could say he's a liar, but we don't know whether he's lying about this or not, saying that Trump would lie about his assets, et cetera. And so in obtaining that GSA lease, again, before he was president, there are major suspicions, there's been all sorts of reporting that they were not honest with the government. And we were also making sure that GSA followed GSA is a federal agency. We were making sure that they followed the rules. So it's very difficult for me to understand how you can have the courts deciding that Congress does or doesn't have a legitimate legislative purpose. I don't know how anybody other than Congress can do that. Again, with some extremely weird examples, again, if Congress tries to criminally prosecute somebody.
But let me push back on that a little bit. And can't Congress just fabricate a legislative purpose? Because again, one of the questions that, where the questions that the oral argument came up were, you're not always passing bills or investigating bills, or doing the initial steps of bills related to things tied to the president's taxes. And the criticism of Justice Alito and others was that, well, what you're trying to get is the president's taxes just for the purpose of making them available to the American people, not for the purpose of actually fixing our tax laws or fixing, what this was about was Donald Trump. So how do you respond to that really there wasn't, and there are times where you just don't have a purpose legislatively. Now, certainly you can make the argument that Congress inherently has the power to engage in oversight, but that's something different than legislative purpose. So how do you respond to that?
Again, very good question, Elliot. There are two key points. The Supreme Court has been schizophrenic about one, and there are many issues, but one, there are various Supreme Court decisions that say that Congress can only get material pursuant to a subpoena as part of its legislative function. And it seems to be talking about its function of passing legislation.
Right.
There are other Supreme Court decisions and that are equally clear that say Congress has a legitimate function to inform the American people. That's part of its oversight function. We strongly believe that that is correct. It's hard to imagine that Congress would be doing anything wrong by saying, we're doing an investigation because we want the American people to know what the executive branch is doing with their taxpayer money. Because again, Congress, we appropriate it, but we're appropriating the taxpayers' money. So there is significant Supreme Court support. And by the way, in the Mazar's opinion, the Supreme Court quoted both of them. So there's significant support for, we can look into the president's tax returns so that the American people are informed. Second, we did have a legislative purpose. We said this, we've set it out in our briefs very carefully. The IRS has a policy, internal policy, about auditing the returns of each president and vice president. In the past, that's not been much of a problem because all other modern presidents have disclosed their tax returns. This is the first president since Nixon who has not. So we said, how is that program done? How's it carried out? Is there political influence? Does the White House call over to the IRS and say, don't look at this, look at that. We want you to skip over this part. Vice versa, do you have the IRS treating the president differently in a bad way? And by the way, Trump, we quoted him as saying a batch of times that he's been unfairly treated by the IRS over the years. So, you don't want career professionals at the IRS, let's say they don't like who the president is, you don't want them treating him badly. So we said, we need to find out, how does this IRS program work? And one of the main reasons we need to find out is, should we put it in a statute? Right now, it's just in an IRS policy. The IRS could say tomorrow, we're doing away with this. And we said, we want to know how this works. And they said, we'll give you no materials. We're not going to give you anything. So you could see whether we don't even know if Donald Trump is actually, he has said he's being audited. We don't even know if that's true. Because,
Sure.
so we did have a legitimate legislative purpose there.
Got it. So last couple questions before we open it up to the audience. And again, folks can submit questions and get them asked. But let's just talk about oversight of the executive branch from the executive branch, right? And inspectors general. Mm-hmm. You and I both know how that works. But can you just explain first, what is an inspector general? Yeah,
and this is a very interesting function that I suspect you could only have in the government. So inspector generals were created. Congress created them. I actually forget the year. I think it was in the 1970s. And they are people. They're officials within the agencies themselves. They are appointed. They're confirmed by they're appointed by the president, confirmed by the Senate. They're supposed to act as, some people, use the word, they're supposed to be a junkyard dog within an agency. So they exist to make sure, is the agency doing things that then they're hiding from Congress, hiding from the American people? Are they mistreating their employees? Are they, are they doing a bad job on things? Because frankly, a lot of what the Inspector General does is at the request of the agency. The agency, is this program working? Are people doing this right? So Congress set those up. There's one for every agency, and then there's an organization of the IGs. It's headed at the moment by a good friend of mine, Michael Horowitz, who's the IG for the Justice Department. And they have certain reporting responsibilities to Congress, but at all times they do work for the secretaries of the agencies that they serve. So they produce a report. Sometimes Congress asks them to investigate certain things. Sometimes the secretary, of HUD or state says, I want you to look into this. They produce a report, and then they show that to the secretary and his or her appropriate people for comment. And plenty of times the secretary will say, gosh, you got that totally wrong. That's totally inaccurate, et cetera. And sometimes they'll say, don't put that part, you can issue this report, but this one part here, people's lives are at stake. Do not publish that, and then the IGs consider themselves bound by that. If the Secretary of Defense says, do not publish this, you will endanger lives of soldiers, the IGs do not think they have authority to go ahead and publish it anyway. The key question, though, is a removal of IGs, because if an IG does something—
that's my next question to you, right?
You don't like what the IG is doing, so you fire him, right? Well, that can make the whole point of the IGs very, undermine it totally. So should it be that you can only fire the IGs for cause? And it's probably important, again, as you've been pointing out, Elliot, not everybody here's a constitutional scholar. The president can fire all of his cabinet members at will. You say, I don't like your face today. You're gone. Or you've done a really good job the past 3 years. I don't have a single complaint about you, but I want to reward an old friend of mine. He's been wanting to be the Secretary of State. So I'm going to fire you. You can leave voluntarily, but if you won't, I'm going to fire you and replace you with my old friend. The president can do that. Everybody knows that, right? The president can't do that to civil servants. But can the president just fire an IG saying, I told you not to look into that. You embarrassed me. I did something bad. Or the Secretary of the Navy said, I did something bad. I was trying to hide it. So I told you not to look into this, and you did it anyway. You're fired. That makes an IG not particularly effective. You need to have a possibility, as you need to have for cause. And so that's one of the things that Congress has been, not surprisingly, looking at, given the recent firings of so many IGs. should it be you can only fire them for cause, meaning
Right.
They messed up.
And an important point, I know for a fact that Justice Department IG, and just one little clarification, Justice Department IG is appointed by a president, confirmed by the Senate, but the term doesn't expire at the end of the president's term.
Right.
So that so what you have is something that traverses presidential administrations, and perhaps they all work that way as well, where it's not just sort of like a political appointment where, on January 3rd or January 20th, 2021, they all get fired automatically. So anyway.
That's exactly right, Elliot.
So thank you for that. So we can open the floor now to questions. I'm not sure exactly how this works, whether I pick them and read them or if...
I can jump in here. Hi, I'm the ColumbiaDC admin. So what we'll do is if you would like to ask your question live, you can raise your hand. And then that will enable me to unmute you so you can ask your question to Douglas Letter or Elliot Williams. Thank you again both so much. This has been really great. So I see a hand coming in, and then once we get through all those hands, then we'll go back to the Q&As. And Elliot, if you want to read some of those, you can jump in, or I can keep going there. So we'll kind of figure that out. But we have some hands here, so let's start with Judith, and then Sarah Wilson, who I believe Doug, you might know from Justice Department. She wanted me to say hello. And Arthur. So we'll start with Judith.
Wait, we can't. My daughter wants to ask a question. Can't we have her?
Is her name Judith?
No.
My name's Judith Evans, and when dinosaurs roamed the earth. And I am also a lawyer. I work in intellectual property law. So my concern is, I believe I heard you say that because Congress has widespread authority and responsibility for appropriating taxpayer money for pretty much everything the country needs, there's almost always a justification and a legitimate legislative purpose to request materials. And that the court, I believe you also said that the courts can't really decide what the legislative purpose is. Now, I'm concerned about that because now I don't work in your field in particular, so I say this with a grain of salt and humbly, but it seems to me that that would give unlimited power to Congress to request anything and everything. And the courts would not be welcome to take a look at whether there is a legislative purpose or not. Typically, when you supply your briefs to the court, you would explain what you think that purpose is. The court often doesn't agree with the reasons that are submitted in a brief, but they do find another reason for agreeing with the petitioner, right? So it seems to me that you're asking for too broad an authority for Congress. I don't think that every single thing they ask for can possibly be legitimate all the time.
Sure. So first of all, as I said, remember, this is a very, Ms. Ours is an extremely unusual case. In the normal cases, the Supreme Court has most of the time upheld when Congress issues subpoenas to businesses, individuals, et cetera. When the court has not, it has not been in general because the court says it's an illegitimate legislative function. Because as I say, that's very hard to find. But the court has refused to enforce subpoenas when, for example, the subpoenas are violating First Amendment rights or Fourth Amendment rights, things like that. So, for instance, during the McCarthy era, there were some subpoenas that were not enforced. But I'm trying to remember. I don't think a single one of them that I can recall said, "Well, Congress can't be looking into this." It was that, as I say, they thought it was violating the recipient's constitutional rights. So I don't, as I said, during in Elliot's questioning, we had reasons, and the Supreme Court did not say that any of our legislative reasons were wrong. So I don't know what more we do. We show, we're investigating the financial services industry to see if it's engaging in money laundering. Is anybody going to tell me is there some court that's going to say, no, you can't, that's not a legitimate purpose? I don't know. One of the things people said to me, and this came up in some of the court arguments, okay, could you get the childhood diary of the President of the United States. And I said, look, I can envision circumstances when no, you know, if you know, a child's diary when she was 8 years old, can the Congress say it's very hard for me to figure out how that could relate to a legitimate legislative purpose. On the other hand, if you're talking about the diary of a president when she was 27, and let's say you're investigating mental illness, is the president still fit to be president? I could see diary entries that would be extremely relevant to that. So
I would agree with you that there's that what you're seeking is reasonable in this case. I was just wondering if there were instances, and you just mentioned there are, where there would be some limitations, even on Congress, for legitimate purpose, legislative person seeing a little narrower than anything they want whenever they want it. And you seem to say, yeah, there would be.
Yeah, what I think the best way to summarize my answer is it's very hard to think of many things that are not legitimate legislative purposes. You can think of plenty of examples why you would say, well, you're not really, this subpoena is not really directed toward one of those purposes. You're just trying to look at the person's diary when she was the president's diary when she was 7 years old to see if you can come up with embarrassing things.
Okay, great. Let's go to our second question from Sarah Wilson. You might have to unmute yourself. Yep.
Hi, Doug. Hi, Elliot. Thanks for a wonderful discussion. My question is Congress preparing for a potential presidential refusal to leave office in the event of a close or contested election? And does it have the power? What power, if any, does it have to act on that potential?
I'm going to pull out my Constitution here. It does have some powers, and look, obviously, these are issues that, especially because of the president's statements the other day, that people are have been looking at. Oh, I'm sorry. I should have this at my fingertips. It says the Constitution says that each house is the judge of its own elections, and so there are situations and also there are provisions about when the Electoral College makes its reports to the report is made to Congress, and the electoral ballots are opened in Congress in front of both the Senate and the House. Oh, here it is. It's Article 1, Section 5. Each house shall be the judge of the elections, returns qualifications of its own members. And then there's, I'm sorry, I can't find it, the later provision about when the electors, presidential electors come, there is a role for Congress. And then there's a statute that was passed, as I recall, in the wake of the famous Tilden-Hayes election, where Tilden got more votes than Hayes, but Hayes eventually became the president. And there was a statute passed about when there are contested elections, there is a role there for Congress. If you really want to read an incomprehensible statute, that's one. It's it's like one sentence that goes on for page after page. It's very hard to understand. So the law does provide a role for Congress, both in the Constitution and in statutes.
Okay, great. Let's go to Jess. Jess, if you can unmute yourself and ask your question.
Sure. Hi, Jess Raben here. I had a lot of questions, but I'll start with this one. On the Mazars case, I was wondering why you decided not to come up with some more definitive limiting principle, because it seemed like a question that the court was going to ask. They asked it back in the ACA case, and it's sort of I know you would prefer that there would not be a lot of restrictions on congressional power, but this court is one that was going to be skeptical towards it. did you sort of invite them to come up with their own test and you ended up with that 4-factor test? I mean, might have been better to offer them something instead of letting them draw one up from scratch?
You know, it's very interesting you bring that up, because I was aware, I'm not on social media, but people told me, oh, I was criticized for that. And what a terrible lawyer I am, you know, et cetera. Come on, give me a break. Does anybody think that I was up there, freewheeling, you know, that, oh no, we didn't, gosh, no, I never thought about that. Give me a break, people. I've done several hundred arguments in the courts. I know what I'm doing. Yes, we obviously thought about that. We talked about it an enormous amount. And the Supreme Court had already told us what the test is. And I said this over and over again. Nixon versus GSA and a batch of other cases, the court told us that the question is if Congress is interfering with the ability of the president to do his job. And the court said that in Clinton versus Jones also. So the Supreme Court had answered that question. Now, obviously, the Supreme Court can change its mind whenever they want. They're the Supreme Court. They can do whatever they want, right? There's nobody, when it's a constitutional question, to overrule them. So the Supreme Court decided, you know, they didn't like their prior test. They didn't feel that it gave enough protection to the president. They were going to come up with a new test, so they did. But does anybody out there, a thinking person, think that we, the House, should have, given that Supreme Court precedent, that we should have said, oh, we want you to review House decisions, and we want you, the judges, to tell us whether those are legitimate legislative purposes? You got to be kidding. Come on, people, you really think I should have stood up there and said that? So, yes, the Supreme Court is going to do whatever it wants. Should I have suggested that they cut back on Congress of power in light of the existing Supreme Court precedent? But as I say, I'm most deeply offended by people who made it sound like, oh, Letter was just totally surprised. Yeah, right. Give me a break.
Well, then.
There you go. There you go, Elliot.
Feisty. So, okay, those were all the hands we have. There are a bunch of written questions, and of course, folks are invited to submit more. And so I'll pick through some of these that we haven't yet hit on that I think might be interesting subjects. One of which, and I'll even give the first answer to this because this is one of the bees in my bonnet. And this is from Arthur E.G. And I don't know if that's Arthur and your initials are E.G. or if you're just saying Arthur, for instance. But for example, Arthur. But Arthur E.G. says, what do you see as the impact on oversight of having so many non-confirmed agency officials? And if I may hijack your event for a moment, Doug, this is an issue on which I have very, 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 very strong views, having worked for both Congress and the executive branch. And I actually think this problem of non-confirmed officials actually goes back to the transition back in 2016 and 2017, when this administration, and again, I want to be clear, if those of you who've seen my bio, you know my background, you know I was with the Obama administration. I come at the world through a bit of a partisan lens, and so full disclosure. However, this is an issue about the successful functioning of government and a failure on the part of the transition team back in 2016 and 2017 to effectively staff the government and to think of the government as perhaps run like a business with the president as the CEO to hire and fire people as he wants. They started on January 21st back in 2017, just not fully staffed. There were a number of very senior positions in the administration that just simply were not filled. And if you remember, there was the hubbub over, is Chris Christie the head of the transition team? And then he was pulled out and they put somebody else in. That actually hampered the successful functioning of government. So what you see today are a number of acting officials in very, very senior roles in the executive branch. Far more. So for instance, I don't have it in front of me because I wasn't prepared for this particular question, but I believe the top, the Secretary of Defense, Secretary of Homeland Security, Deputy Secretary of Homeland Security, General Counsel of Homeland Security, Director of ICE, Director of Customs and Border Protection, all of these national security agencies right now are being led by acting officials. And you might think, well, these are people who were promoted from within. Well, maybe it's not a big deal. It's actually a really big deal for two reasons. One, if this were a business, which it's not, but just to analogize, if this were a business, it is bad for morale to constantly have people who are sort of placeholders in their jobs and not able to effectively, to know that they will be the leader next week and the week after that. It's hard to motivate workers and employees around officials that they just know might be gone at any given point. That's one. Point two is actually more serious, and this came up I remember during when we were working on the confirmation of Sally Yates to be Deputy Attorney General. There are a number of jobs in government that can only be filled by someone who has been confirmed by the Senate. For instance, there are about 4 or 5 jobs in government, Doug, you may know this, I don't know, but 4 or 5 jobs in government that can sign FISA warrants, for instance, like the Attorney General, the Deputy Attorney General, the head of national security at the Justice Department, the head of the FBI, and they can't be acting officials, right? So when there are a few jobs that actually go to the nation's safety and security that you just can't have acting officials in. And this idea put forward by the president that, well, I like acting folks, I like being able to move people in and out. It's actually very much something that makes the public less safe and is just bad for the successful functioning of government. So it's a big deal. This transcends party politics. It's just bad government and bad management of government. Now, that's the sort of bigger, broader macro question. On the micro question of what's the impact of having so many on oversight, I'd be curious to hear what you think, Doug. It seems to me you could still call in an acting official to testify and subpoena documents from an acting official, and probably, frankly, have an easier time getting them there because they're more junior or just, not someone who ran for president a couple of years ago or whatever. The problem gets back to what you talked about at the beginning of this, which is that they're just not sending anybody up to testify and not presenting any documents. So regardless of whether these individuals are acting or not. So that was my 84 cents, more than 2 cents, but I'd love to hear your thoughts.
Elliot, I agree 100% with everything you just said. And the only thing I would add is, if you call up an acting person, a lot of times they'll say, I'm carrying out a policy that was set by somebody who had been confirmed by the Senate, and I don't feel comfortable overriding a decision by somebody who has been confirmed by the Senate for that position when I have not. And so it's too easy, and I'm not even sure that it's bad faith for them to duck, but it's too easy for them to duck. But no, I agree with you, everything you said 100%.
Great. Eric Hirschhorn asks, might a cynic, and I don't know if Eric Hirschhorn is asking on behalf of all cynics or if Mr. Hirschhorn is himself a cynic. However, the question is, might a cynic say that the 4-part test, so this was in the Mazars case that we talked about, and remand, so that's sending it back down to the lower court, was nothing more than the court majority trying to have it both ways. They wanted to rule against Trump, but in a way that could effectively ensure that nothing would be released to Congress or the New York County District Attorney before the election. What do you think?
Look, many commentators have said that. Plenty of commentators said we and Mr. Vance, the New York District Attorney, won major victories. Trump argued basically for absolute immunity. We can't seek his personal records. He lost big on that, and a lot of people have said that. But obviously what the Supreme Court did pretty much guarantees that it's going to be very hard for us to actually get documents before early November. And to further that, I won't go into details, but the Supreme Court, when it issues its decision, that is not immediately effective. It's not effective until the Supreme Court issues its judgment, which sometimes is about 30 days later. So the lower courts can't act before the Supreme Court does that. So we asked the Supreme Court, would you please expedite issuance of your judgment so that we can get going in the lower courts? And Trump opposed that, and the Supreme Court said no. So, gosh, we couldn't even get expedition to start trying to meet the Supreme Court's test, because we're going to. We can meet the Supreme Court's test, and we're going to. But question of how soon can the courts rule?
Now, I guess a test of your the Congress's sincerity with respect to, saying that you actually have a legitimate legislative purpose would be if you would still continue to seek the documents after President Trump is out of office. If you are in fact seeking to reform the IRS or whatever, certainly it doesn't matter whether Donald Trump is in office or not, because these documents would be relevant to whatever legislation you're passing. I mean, I think people are right to have a fair amount of skepticism that this is about Donald Trump and his misconduct and his behavior, but
Elliot, that's a very good point, except we won't really be able to find out, because remember, the Supreme Court said this is a separation of powers problem of Congress and the sitting president. So if he's not sitting anymore, he doesn't, the Mazars decision, I don't think applies at all. He's just, remember, he's just private citizen Donald Trump. And we have tons of case law saying that we can issue subpoenas to private citizens, again, unless we're violating their First Amendment rights or something. So I don't think we're going to be able to test that.
Got it. So Rona and Gil Eisner ask, if the Supreme Court agrees that the president should respond to a subpoena, what happens then?
Oh, well,
$1 million question.
Yeah, it's obviously reminiscent of, I'm not sure whether historians have decided this is apocryphal or not. The great Chief Justice John Marshall issued a decision that Andrew Jackson didn't like. And so Andrew Jackson supposedly said, basically, yeah, you and what army? I think he said, supposedly said, okay, John Marshall has his decision. Let's see him enforce it. And supposedly Jackson's cabinet said to him, no, we're going to be a rule of law in our society. And Jackson relented and decided that he would follow what the Supreme Court had ordered, even though John Marshall had no army. I don't even think he had law clerks. Maybe they had a bailiff. I don't know. So, if the Supreme Court enforces a subpoena, I think we'll be fine, because remember, and this is a very, very key thing, and I'm sorry I didn't get to it before, Elliot. Remember, for example, we subpoenaed records from Deutsche Bank. Mm-hmm. Plenty of those records are not Donald Trump's. They're, for instance, Deutsche Bank's own analyses of Trump's application for a loan. The Supreme Court long ago made clear that you don't have a privacy interest under the Constitution in that. You have statutory privacy interests, but they don't apply against Congress. So those are not Trump's documents. Those are Deutsche Bank's documents. So if we get a subpoena enforced, it would be an order against Deutsche Bank. So Deutsche Bank would have to turn, or Mazars, they would have to turn over the material. The materials are not sitting in the Oval Office. They're at Deutsche Bank and Mazars. And that got to the burden question too. The Supreme Court said, you can't do this if it's a big burden on the president. I pointed out that there's no burden on the president. We didn't ask for the documents from the president. He doesn't have these. He doesn't have to look through them or whatever. They're at Deutsche Bank and they're at Mazars. And both of those have never said anything about burden. They never once said to us, oh, we can't produce these, it's too great a burden. Not once do they say that.
Okay. So I see from Robert, and forgive me if I get your name wrong, it's Mialievich, regardless of and I'm going to amend the question a little bit after I read it. He says, regardless of the party in power, we seem to have an ever increasing number of investigations in recent years. What's going on? And does this go back to Nixon? And the way I would amend that question is, do we have an increasing number of investigations, or is the public just more aware of them now? And is the public just getting more hopped up about them because of our media, the 24-hour news cycle or whatever? But to the underlying question, is there an increasing number of investigations, and what's this all about?
Yeah, it's a great question. And my impression is that what you just said, Elliot, is right. We're more aware of them. But one of the things in research, we did a lot of historical research on before, in the our Mazars Deutsche Bank brief. Again, social media out there, we knew what we were doing. We did a massive amount of research, and we found that there were numerous investigations of presidents and their personal lives and things they did, and their spouses and their brothers, et cetera. It's sort of not new.
Oh, straightforward. Huh.
Yeah.
Okay, Mark Coles asks, does the presidential power to pardon override Congress's power to investigate? Can the president pardon himself?
Oh, that's really good. And here, I'm going to let the Justice Department talk. And, Elliot and I both worked at the Justice Department. I worked there for 40 years. Elliot worked there for quite a few. The Office of Legal Counsel at the Justice Department has said that the president cannot pardon himself. So that's the executive branch talking. They said, no, can't do it. Very interesting. So that, then, if one of the things is, suppose the president pardons somebody. The Supreme Court said in the wake of in Reconstruction, a decision, Garland in the 1860s, I believe it was, that the presidential pardon power is sort of unquestioned. Well, that can't be right. And in fact, the Supreme Court has sort of cut back on that. Suppose there's a bribe. Suppose somebody bribes the president to pardon him or her. And the person stupidly brags about it afterward and says, yeah, and it only cost me $50,000 to get that pardon, but the president, he's desperate for money right now. Surely that's a crime. I don't think there's anybody who would say, no. The president can take bribes and pardon people. So does the pardon power override the oversight power? And I don't see how it could, given that a presidential pardon can be actually a crime. And remember, clearly a president could be impeached, it seems to me, for it. If the president is taking bribes, maybe you can't prosecute, that's unclear, but you could impeach him, surely. And so obviously Congress could do an impeachment investigation and say, did you bribe the president? Yes, I did. And then the president says, oh, he's lying. You say, okay, Mr. President, he's lying. You testify. Tell us what happened. And, that's what we did. We tried that in impeachment. And Trump said, nah, I'm not going to participate. Michael Cohen's lying, but I'm not going to participate.
So the next two questions are sort of turning the temperature down a little bit on Trump versus Congress and some of these lofty questions, and just beautiful questions about how this stuff works for you as an expert. So Gabrielle Vetter Taffy, again, forgive me if I mispronounced you, but basic question out of curiosity from an organizational perspective: to whom is the position that Mr. Letter occupies accountable to? The Senate Majority Leader and the House Speaker, or to whom do you answer, and who's your boss, and how does that work?
Yeah, very, very simple. I am appointed by the Speaker of the House, and I report directly to Nancy Pelosi. I'm provided for under, actually there's a statute that provides for it, but in addition, it's governed by House rules. I'm not like the clerk or the sergeant at arms, officers of the House who are elected. I am appointed by the Speaker, and I report to her. And she is guided in how, and she's really indeed my boss. I talk with her all the time, and she makes the decisions. She tells me what to do. She makes the decisions, and she consults with something called the Bipartisan Leadership Legal Advisory Group, which is made up of the Speaker, the Majority Leader Steny Hoyer, the Majority Whip James Clyburn, the Minority Leader, Kevin McCarthy, and the Minority Whip, Steve Scalise. Now, remember, I think there was a question there about the Senate. The Senate has their own counsel that's totally separate. And the Senate Legal Counsel has very different functions than I do.
Well, let's get into some more of the specifics about your job, though. First, and this is my question, is sort of a follow-up to that one, does the minority have a separate general counsel because, so case in point, the Mazars litigation stemmed from investigations that the House majority, the Democrats, were bringing. And certainly Kevin McCarthy and the House Republicans would not have the same litigation interests frankly, or even on behalf of so imagine the House, sorry, I'm a little garbled here, but the House Judiciary Committee wants to bring a subpoena, right? And that's what this fight is over. There's 25 members of that committee are Republicans who voted against that subpoena. So certainly you as general counsel to the House may not represent their litigation interests. So my question is, do the Republicans have their counterpart, Doug Letter? Or, not that there could be ever, but is there a similar role?
Right, and I'm so glad you asked that question. And for instance, in the Senate, there's a Senate legal counsel and a deputy legal counsel, and normally one is the majority, the Republicans now, and then the deputy is would be for the Democrats. And the two of them have been there they're both good friends of mine, and sometimes they switch depending upon who's running the Senate at the time. We don't have that. I'm appointed by the Speaker. My predecessor, Tom Hunger, who I'd worked with at the Justice Department, was appointed by Mr. Ryan. He reported to Mr. Ryan. However, the reason I'm so glad you asked it is a lot of what I do is nonpartisan or bipartisan. So I represent when the members get sued or their staff, as long as it's not employment stuff. Employment stuff, that's a totally different office. But members get sued all the time. And so I represent them, I file briefs, et cetera. Members might be, we had a situation, a former member was being asked to testify before a grand jury. It was not an investigation of that member, but they thought he had been a witness to some stuff when he had been on the Hill, and the grand jury wanted him to testify. So we, represented him, meaning we met with him, we negotiated with the prosecutor about when he would testify, things like that. So we were representing, a former member of the House, and it so happens he was from the other party, but that made no difference. Members can get their own attorneys if they want. That's up to them entirely. So there was a situation where somebody had sued one of the members and she decided to have her own attorney, but then that attorney was consulting with us and getting assistance from us. So there's something called the speech or debate clause, which provides absolute immunity for legislative activities of members of Congress. People sue them all the time. So I go around asserting immunity for members of Congress, getting them out of situations. I provide advice my office does advice all the time. A chief of staff, a member's chief of staff back in his or her district suddenly gets arrested for something. They have their office phone and their office computer with them. Can the local cops look through those? We say no. So somebody from my office might call the local cops and say, you can't look at the work computer or the work phone. If there are things you want from that, you talk to us, et cetera. If the FBI is investigating members or staffers, a lot of times they come to my office first and we help them. A lot of times we work with them. We help them figure out what's the best way to get documents they need or testimony, depositions, et cetera. So I have a whole function that is not, me representing the political interests of the House, but otherwise I represent the House as an institution as directed by the Speaker of the House, because the House works on majority rule. That's what it is. I'm just sorry. Let me just tell you one quick thing. The House, because of the pandemic, the House knows it's unsafe for many members to come to the floor. We've had a batch of members who've tested positive. A lot of members are elderly, or they have health problems, or their spouses or kids have health problems. So the House put in place remote voting rules. Some of the Republicans didn't like it. So Mr. McCarthy, minority leader, sued Pelosi, the Speaker.
Oh, wow.
And so I'm representing, I just had a 3-hour hearing about this in court on Friday. I represent the House because again, it's majority vote against Mr. McCarthy and 100 and something Republican members.
That's like being called to testify in your parents' divorce dispute over custody. Like, you know,
very long-winded answer. No, there is no, unlike in the Senate, there is no separate one of me. However, Mr. McCarthy has a counsel who is an extremely experienced House veteran, Michaela Carr, and she's very, very talented. So sometimes I work with her.
Excellent. Another question, I'll amend it a little bit. Could you please discuss your experience with telephonic oral arguments? We haven't talked about COVID at all, and this is actually a wonderful question. Telephonic oral argument, this is from an anonymous attendee. And what effect, if any, you think it might have had on the Mazars case? And even if not, let's make it two questions, right? One, what effect it might have had on the Mazars case, but even more generally, you've argued in front of the court multiple times. What effect has have telephonic arguments just had on the proceedings of the courts?
Yeah, it's interesting. And by the way, some telephonic arguments are by video. The one I did just the other day in front of Judge Contreras was video, even though remote. In the Supreme Court, I don't think the form of the oral argument makes or made a difference. The thing that's really interesting is when you're arguing in the Supreme Court live, there are 9 justices. As we know, Justice Thomas often doesn't talk, but he did in the video, the audio ones. The justices ask a question, and then sometimes you get out like 2 words, and then another justice interrupts, and then another justice interrupts that one, etc. So oral argument in the Supreme Court, a lot of times it's just this cacophony of voices, and you can hardly answer anything sometimes. Because of the way they did the oral argument, Chief Justice Roberts would go one by one, and the justices asked a question, and you could answer that question without anybody except that justice interrupting you. Sometimes the Chief Justice would interrupt because he wanted to move on. But so Justice Thomas actually asked questions, and you could, I know this is crazy, you could actually answer the question. I mean, so in that sense, I thought it was wonderful. The bad side is, look, as you say, I've argued several hundred times in the federal courts. A lot of times, you pick up cues, visual cues from judges. If they ask a question and then you start answering, you can tell, no, they're bored. I've had justices sleeping on the bench, etc. Judges, I'm sorry, sleeping on the bench. So, you pick up visual cues that obviously you can't get if it's simply over the phone.
Another question, and I think this is going to be the last one. There's a few others that sort of get off the topic of the House of Representatives and sort of executive power and more just sort of questions about Donald Trump and so on. I think we'll avoid tonight. Maybe that's another event. But yes, let's make this the last one. Why hasn't the House acted on what some members allege is the president's continuing violation of the Foreign Emoluments Clause? So first, what is the Foreign Emoluments Clause? Let's talk about what that is. And then second, why hasn't the House acted?
Right.
Or I guess third, if you don't buy the premise of Jess's question, has the House acted, and do you just disagree?
So several answers there. The Emoluments Clause, the Foreign Emoluments Clause says that certain levels of government officials, not just the president, can't get things from foreign states. What the framers were really concerned about is it used to be a very common practice. The French ambassador would arrive in the United States and he would give a gift of, like a fancy horse or something like that. It was, it was a way of, and our ambassador to France would be given all sorts of gifts to try to, influence them. And the framers didn't want that, so they said you're not supposed to get these things from foreign states. Very difficult to figure out what is or isn't an emolument. I think there's either no case law or almost no case law. The Constitution says that the Congress can give permission, though. So if the King of France says, I really, really want to give George Washington the following, Congress could say, sure, let him take it. But so one question is, it's not really clear what an emolument is, but so I'm not sure what action we could have taken. One question is, could we sue? And the problem there is the Trump administration, the DOJ, said the House can't sue. I argued in bank in the DC Circuit about the appropriations clause, the Trump administration unconstitutionally taking money and using it for the border wall, even though Congress said you can't. He did it anyway. So we tried to sue about that, and that's been tied up in court. So it's not really clear what the House could do. A batch of members of the House and the Senate sued, but it wasn't the House suing. And again, I take direction from the Speaker of the House is my boss. So, there could be legislation about that. We'll see. But obviously it's not, the Constitution doesn't say what we can do. I suppose we could say, if the Senate woke up, they could say, we won't confirm your next Secretary of State nominee unless you stop accepting, emoluments from the Saudis. But, we don't have the authority to do that in the House.
So great. I think that's where I'm going to stop with the Q&A. Is there anything that we left out that's burning on your mind that you want to raise for the collected community of Columbia and University of California?
Yeah, I guess I'm so thankful for this opportunity. I got an amazingly wonderful education as an undergraduate at Columbia and Berkeley law. I think maybe I mentioned this to you, Elliot. The great thing about Berkeley, when I graduated in 1978 as a California resident, I think I was paying about $200 a semester. So I got an absolutely first-rate law school education from the University of California at Berkeley for extremely little money. And I hope I've paid California back because my entire career has been in public service. I'm a career public servant who has served Republican and Democratic administrations, completely. And so I hope I've paid back the other citizens of California for that.
And you didn't even have to do any of them as webinars or virtual streaming classes. Like you could actually, sorry, too soon for those of you who have
Too soon.
college now. Is that we shouldn't go there?
Well, we'll see. But thank you so much to both of you. Thank you, Elliot. Thank you, Counsel Letter. It has been an education. I have to go rewatch the clips, which we're gonna post tomorrow. So we will receive an email about the recording so that I review where we stand legally. Thank you so much.
Thank you.
My pleasure. Thank you, Elliot.
Thanks, Doug.